Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip is a continuation of the changes to the 2022 Georgia Association of Realtors, or GAR, contract package. So today I am going to, please check out the videos I've already done. I'm breaking this up into sections. And also we are teaching CE classes, a 3-hour CE class on this through the Georgia Real Estate Academy. I will link the training calendar below. But today I want to cover changes that GAR made to the exclusive seller brokerage engagement agreement. That's a mouthful. This used to be called, refer to it as the listing agreement. This document underwent major changes last year. So today, or for 2022, just a few changes, and I am going to go over those now. So again, this is called the Exclusive Seller Brokerage Engagement Agreement, and it is Form F-101 in the Georgia Association of Realtors contracts. Before I go further, I just want to state that in Georgia, the client relationship is created via contract. So the client relationship between a public seller and a broker is created contractually. So I'm bringing this up for a couple of reasons, but just wanted to point that out, and that is license law and Georgia law, OCGA 10-6A-1. State law prohibits broker from representing seller as a client without first entering into a written agreement with the seller. So this is the written agreement that does a couple of things. Number one, it creates the client relationship between the public seller and the broker, and then you, as the affiliated licensee with the broker, can thereby advise and guide the seller what they need to do to represent them as a client with respect to the sale of their property, their real property. Again, I'm going to come back to that concept in just a minute. So again, major changes in 2021. What they have done in 2022. Well, in April of 2021, they separated out paragraph A2 and A3. So in January of 2021, they created two dates. One is the initiation or the start date of the actual seller brokerage agreement. And then there is a separate date, which was the marketing commencement date. So that change took place in January of last year. In April of last year, they teased out these paragraphs a little bit more just for ease of understanding and just to make sure it was just a little bit, well, just for ease of understanding, number one, and number two, to comply with the MLS rules and regulations. So in paragraph A2, it has list price. You fill in the list price, and then it has the listing period. And in paragraph A2B, it has commencement date of agreement. And you fill in the date, and it says this agreement shall commence and be effective upon it being signed by the seller and broker, and a signed copy delivered to both parties. That date is what creates the client relationship. It has nothing to do with marketing or advertising the property yet. It just has to do with the client relationship that is created between the public seller and the broker. And that's when you can advise the seller what they need to do, go over list price, negotiations, timing, so forth and so on. And then, of course, you have to have an end date. Then in paragraph A3 is a whole separate paragraph on marketing. And it says the broker agrees to file this listing with the following multiple listing services. And again, that's going to be the MLSs that the brokerage belongs to. Then, here's what they changed in April of 2021. Delivery of this agreement to and listing with MLS. This agreement must be timely delivered to and listed with the above referenced multiple listing services in accordance with the rules of such multiple listing services. This obligation shall control over any conflicting or inconsistent language contained herein. And then paragraph A3B says marketing commencement date and has a fill in the blank for a date. This is the date when the property is first marketed to the public. Seller shall have the right upon notice to the broker to move this date up. So let me just briefly go over this. Again, the list, when this seller brokerage agreement is signed, that's what initiates or creates the client relationship with the public seller and the broker here in the state of Georgia. Then the marketing commencement date is when the property is first available to the public for showings. So per your MLS, I'm just going to talk about FMLS because I know more specifically about them. If you are an agent or a broker in Georgia and you belong to a different MLS, you're going to have to go over their rules and regulations and policies. But for FMLS states that once an exclusive seller brokerage agreement is signed, it must be listed in FMLS within within two. It has 40. You have 48 hours from the date the brokerage agreement is signed to list it in FMLS. It belongs to FMLS. FMLS is due fees when it closes, and it must be listed within 2 business days of when the seller signs this. Now, when you have the marketing commencement date, what that has to do with is the status that it gets listed in FMLS. So if the marketing commencement date is the same date as when the seller signed it, then it gets listed as active, and it's available to be shown by the public, by other members of the FMLS, by agents within your own office, by your own sign calls. It's available to be shown as of that date. If the marketing commencement date is a date after the date the seller signs it, then the status that it goes into FMLS is that of coming soon. If it is, so it still has to go in FMLS. The marketing commencement date merely has to do with the status that it gets listed as. So if it is coming soon, it cannot be shown to the public. It cannot be shown by your own sign calls, by anybody in your office, by any member of FMLS, by any member outside of FMLS. It cannot be shown to the public. What it is it is exposed via FMLS to other members of FMLS as far as what you have listed in the listing service, but not to be seen in person. So, point of practice tip to you listing agents: if you have a property that's in a coming soon status, do not put a lockbox on that property because you cannot show it. And this also has to do with the Realtor Code of Ethics. The Realtor Clear Cooperation Policy. So also the issue is if the broker is a member of FMLS, if there is an exclusive seller brokerage agreement signed, and if the property is in an FMLS compulsory area, it is required via that membership to be listed in FMLS. If you are a member of Georgia MLS and FMLS, any and all properties listed in FMLS must also be listed in Georgia MLS. If you are a member of another MLS service, you need to check with their policies and procedures. So those two paragraphs, the actual commencement date of the client relationship and the marketing commencement date, got teased out. Well, they got created in January of 2021, and they got teased out for clarity, as well as that verbiage about MLS in April of 2021. Then for 2022, under the paragraph about the type of agency that the brokerage allows, again, this just got changed just a little bit to make more sense, because paragraph A6 has agency and brokerage. The following are types of agency relationships not offered by the brokerage, and one of those is dual agency. And so what it used to say is it used to have a consent question to the public seller about dual agency. But right above there, it said if the brokerage does not allow dual agency. So all they added was just verbiage to make the next section a little bit clear. So again, paragraph A6, agency and brokerage. The following types of agency relationships are not offered by the broker. That had always been there, dual agency being one of the options. For 2022, this is what they added, is subparagraph B. If the broker does offer dual agency as one of its agency relationships, the seller does or does not consent to the broker acting as in a dual agent capacity, as that agency relationship is explained in the next section. Then another thing that they changed in April of 2015 is in the explanatory paragraph, paragraph B3B, under the marketing. Just what I just went over is it talks about, they just added a little thing about internal marketing, again, regarding the MLS services. And it just says internal marketing that goes to other licensees within the seller's brokerage firm is not considered public-facing marketing unless it is distributed to licensees outside of the brokerage firm. Then under paragraph B4C, under commission, this is something that in our brokerage we have always advised as a special stipulation, that if to add a separate commission on a lease. So you could have a seller that puts a house up for sale, and then due to an offer they receive or a change in circumstances or whatever, they end up leasing the property or doing a lease purchase. And there was always an issue. Well, what about commission? Is there commission owed on a lease? And we always had a special stipulation that we provided for our agents to include should the seller that had a property up for sale end up agreeing to a lease purchase, a lease option, or an outright lease, commission would be owed. So GAR has actually added that into the seller listing agreement, and it is under paragraph B4C. Under B4 is the commission under C, separate commission on lease. Notwithstanding the above, if seller leases real property or enters into a lease purchase or lease with an option to purchase contract during this agreement, the seller shall also pay the broker a separate leasing commission in the amount as indicated elsewhere in this agreement. Notwithstanding any provision of the contract contained herein, the payment of a leasing commission, including in lease purchase and lease with an option to purchase transactions, shall not relieve the seller from paying the commission at the closing of a contract to sell provided elsewhere. So it is a separate or partial commission paid at the time of a lease. Then they have moved the hang on, I'm a little confused. I apologize for that. Under I skipped a whole page. Okay, sorry about that. Let me go back. Under paragraph A, under the commission section, so it's under paragraph A4 under commission, they've just added a reference page number if there are additional pages. And they have moved the protected period under commission because what are you protecting? You're protecting commission. So they moved that. And then that was before the dual agency section. So I apologize for that. I missed that a little bit. Just a little bit out of order. So then under C, under the paragraph where it's talking about other terms, they changed this. This was a mid-year change that GAR made in April of 2015. And if the property was built prior to 1978, the seller is required to complete a lead-based paint disclosure. So the verbiage they added to the exclusive seller listing agreement and the non-exclusive seller listing agreement in April of 2021 is that the seller shall complete that lead-based paint listing disclosure at the time they sign the listing agreement. So, point of practice to you listing agents. When you are going on a listing appointment, bring the lead-based paint disclosure with you along with the listing agreement so that the seller brokerage agreement so that the seller may complete it while you are sitting there. This form is a GAR form, or you can get it from www.epa.gov. Then under the miscellaneous paragraph, paragraph C4, the definition of a seller and buyer, that used to be defined in the protection period paragraph. but it was just a little bit odd for it to be there. So they moved it under the definitions under the miscellaneous section. So none of that has changed. It just defines what a buyer and seller are, their heirs, their estates, if they're a member of an LLC, so forth and so on. In essence, so there's no confusion over who owes commission, should there be any confusion over what is actually defined as a seller. Then also in April of 2021, under the referral section, they have just added a section that the broker, the seller hereby authorizes the broker to refer the seller to another real estate licensee or broker or brokers for relocation services. And they added or to a builder for builder services. So that's a great addition. And under paragraph C7, brokers and sellers duties, they have reworked this paragraph again in April of 2021. So the majority of these changes actually occurred mid-year last year, but wanted to point those out since you guys are looking at your contracts and all the agreements for the changes made in 2022. So mid-year of last year, under these broker and seller's duties, under broker's duties to seller, this got a little bit revamped mid-year last year, and it just says broker's duties to sellers. Brokers shall promote the interest of the seller by seeking a sale price at the price and terms stated in the agreement or at a price and terms acceptable to the seller, provided, however, the broker shall not be obligated to seek additional offers to purchase the property while the property is subject to a contract to sell, unless the brokerage engagement so provides. 2, timely presenting all offers to and from the seller, even when the property is subject to a contract to sell. In other words, even if it's under contract, there is still an obligation to present all offers and counter offers. 3, disclosing to the seller material facts which the broker has actual knowledge of concerning the transaction. 4, advising the seller to obtain expert advice as to material matters which are beyond the expertise of the broker. And 5, timely accounting for all money and property received in which the seller has or may have an interest. Again, it's just a little bit revamped from the January 2021 paragraph regarding brokers' duties to the seller. So that's about it for the seller brokerage agreement. Not a whole lot. Stay tuned. I will have a whole separate video on changes to the buyer brokerage agreement, as well as other 2022 changes to the GAR, Georgia Association of Realtors contract package. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.